I'm Terry LaPorte with the LaPorte Law Firm. Our firm has represented tens of thousands of clients at hearings with Social Security judges over the last 45 years or so. So we built up a lot of knowledge about best practices for our clients and some mistakes to avoid. Now, before the hearing, know that your judge has read your file. The judge has read the legal brief that your attorneys filed before the hearing and knows from the brief and reading your medical records what your case is about. So you don't have to explain everything to the judge. The hearing is your opportunity to put into your words how your health conditions have impacted your ability to be productive in a reliable full-time job. Now, during the hearing, you should be pleasant and cooperative, and you should be respectful and not exhibit frustration with how horribly slow the Social Security process has been. That's not the judge's fault. Obviously, be honest. You're under oath. Tell the truth. Above all, don't exaggerate. Don't say you spend all day in bed if the judge can see medical records and forms saying that you drive or attend doctor appointments and do your own cooking and cleaning. If your condition is one where most of the time your pain or fatigue or other disabling symptoms are not really that bad, but you have 3 to 10 days, maybe in a month, where you have to lie down for hours during the day, stay home, say so instead of exaggerating your problems by saying that you constantly have disabling pain. Before the hearing, prepare with your attorney your truth, explaining how your health impacts your ability to reliably work full time. Complete honesty is important when a judge is on the fence about whether to believe you with your testimony about how severe, say, your pain or your concentration problems are. So many judges have told me that they sometimes test your honesty by asking you about things that they know you don't want to talk about. And one example that comes up sometimes is whether you had a DUI in the past or you've used illegal drugs. If you're open about your drug or alcohol use, which you and the judge know has nothing to do with your bad back or unstable knee, which is the reason you can't work, the judge might then decide to accept the sincerity of what you're saying about your pain and how it keeps you from working full time. So be an open book. Also, be consistent. If you've told your doctor who wrote it down that you regularly have had 5 to 10 migraines a month or 2 seizures a month, or that you can only lift 10 pounds, you're going to need to be consistent with those same kinds of answers that you're hearing, or be ready to explain why that was true then and now something else is true. What changed? Prior to the hearing, we can go over with you the medical records so you can see what the judge has also reviewed and might be prepared to hear some testimony about from you. Now, focus on the question from your judge or your attorney and answer only the question. The judge has set aside only maybe 45 minutes, sometimes an hour, 60 minutes for your hearing. After all this time, that's all the time you're going to have for your hearing. And you might answer questions for only maybe 20 or 30 minutes of that time, with the rest of the time in the hearing involving vocational expert testimony, sometimes medical expert testimony, and then the discussions between the judge and your attorney. So focus on the question from the judge, answer only the question. This isn't a conversation, it's Q&A, okay? So that means if you're asked a question that requires only a yes or no answer, answer with a yes or no. And without an explanation on why it's yes or no, keep your answers brief and on point. Judge has another hearing shortly after yours. Your attorney will be able to prepare you with the key points we want brought out in your testimony so that you can explain answers and explain how your condition limits you and practice you about that kind of testimony before the hearing. I tell my clients not to think that you have to impress the judge with a statement that you're a person of character with a strong work ethic. In my early career, that was a common thing for my clients to say. And after a while, I would talk to the judges and they say, look, we've only got limited time here. The judge is going to think your motivation to work will often be very clear already from your documented work history and the payroll taxes that you paid over the years of your work. Judges reviewed all that before the hearing. And while I don't ask about the work ethic, I do often ask one question to my clients about what they miss about working. Obviously the paycheck, but also the coworkers and friends they had at work, and often what my clients like most about the work itself. So really what they miss about working. At our firm, we know it's been a difficult adjustment in your life that you've had to stop working because of your health problems. And now you've been waiting a long, long time to directly talk to a human being, the person, the judge, who can overturn the two faceless denials of your claims at the initial and reconsideration stages. At the LaPorte Law Firm, we'll work with you to help you build the best case for the approval of your disability appeal. Thanks.